right, be seated, please. All right, ladies and gentlemen, what we're going to do at this point are what we're going to call closing arguments. Ms. Prevet will go first. She's the prosecutor. Then Mr. Herzog will make a closing argument. Then Ms. Prevet will make, if she wants to, what's called a rebuttal argument to counter what Mr. Kirchhoff says because she has the burden of proof. I will then give you some instructions on the law you are to follow in this matter and during deliberations, and then we'll get you deliberating. Okay? Go ahead, Ms. Prevet.
Thank you, Your Honor. Good afternoon. Thank you again for your time and attention during the course of this trial. I know you have been very attentive and also very timely, as Judge Quist has referenced before too. So thank you for that. I know it's been a long week, but of course it's a very important case to both sides. And so now that you've been here all week, you know why we're here. We are here for what happened to Maya Kelly back on December 26th of 2022 when she was at her home at 47 Canton here in the city of Grand Rapids. She started off that evening with her boyfriend, Omar Dana, and her two young kids, simply going to watch a movie. But then she went to open this door, and her life ended. And she ended up like this. So when such a tragic and senseless murder happens, we have to ask how and why, right? How did this happen? We know from the evidence here that this was an intentional and premeditated act of the defendant. The defendant shot her in the head in front of her two young kids who were in that very room. One was right by her and one was a little further away, but it was happening right in front of their young eyes. We know how it happened. So why did it happen? And I submit to you there's no good reason or acceptable reason as to why this happened, right? It's not something we have to prove either, but something you will likely consider during the course of your deliberations. We don't have to prove motive. We don't have to prove the why. We only have to show that the defendant committed this crime, and that's what the overwhelming evidence in this case shows. But I submit to you that if we at least didn't try to figure out the why or to determine the motive, you would likely question us, right? Or the police investigation. So again, there's no acceptable reason whatsoever as to why this happened. But we at least tried to figure it out. You heard during the course of this trial, that in that neighborhood, snitching is a big deal. You heard that term from Detective Bayless, who told you what a snitch is, and that people don't always want to cooperate with the police. Why? Because snitching can be life or death. People don't always want to cooperate with the police. So consider the danger that some witnesses perceived or felt that they were in if it looked like they were cooperating with the police or testifying or giving statements. There was a perceived danger to many witnesses in this case. And snitching may be what led to the death of Maya Kelly. No wonder why certain witnesses are reluctant to cooperate or testify in cases like this. I mean, you heard from a number of them, including Marquise Welch, Caitlin Hines, and Jasper Keys. These witnesses were not eager to testify in this case. They were somewhat reluctant, for good reason in their mind, their perceived danger, if it were shown or it looked like they were cooperating with a police investigation. So you may not know exactly why this happened, but there were some possibilities for why this happened, right? You heard a number of times the name Terrell Franklin, Marquise Welch, and of course Keyante, the defendant. I mean, these three men in this somewhat inner circle, they were entwined. They all knew each other, they were friends, they hung out with each other. And what's something that they all had in common? They were not on good terms with Omar Dana on the date of this murder, on December 26th of 2022. So what do we know about Terrell Franklin? Well, we know that he was mad at Omar Dana. We know that he was mad at Omar Dana about what happened on December 19th, right? When Terrell Franklin was arrested from 47 Canton, and he thought that Omar or Maya had snitched on him. had got him in trouble in some way, had cooperated with the police, that they had snitched. So Terrell was still mad at Omar on the date of this murder. On December 19th, Terrell Franklin went to jail. He was arrested from 47 Canton. We know through the evidence that the defendant was friends with Terrell Franklin and that he was with Terrell Franklin on December 19th. And we didn't get into a lot of details about what happened at the graveyard or the cemetery, but we know from the evidence that Terrell Franklin was with the defendant. We know that Marquise Welch was friends with Terrell Franklin and the defendant. And after December 19th, all three of them essentially are on bad terms with Omar. Terrell Franklin is in jail. The defendant was not. He was out. And Marquise Welch, he had the car, right? He had the car that was able or allowed this to happen. So they were all connected. And they all had problems with Omar Dana. We heard from the defendant that he confirmed that Terrell Franklin had got into it, or his words, with Omar Dana on the phone on December 19th. You heard that through his words in the investigative subpoena.
I'm going to show you one at a time. If you recognize the person, number two. Who's that?
He set up little organ boys. Like this is Terrell, my cousin. You know what I'm saying? Friend. I know who he is, but man, I ain't seen him in a minute because him and Terrell got into it when we was on the phone. And they were talking about Marshawn, because we was supposed to go on Marshawn Graves. Like, that's when I really thought this was over. Terrell at the gravesite shit. And he was talking to him, trying to ask him, like, where's the gravesite at so he can piss on it. So, like,
So in this, the defendant is saying that's what he thought this was all about. The stuff that happened with Terrell at the gravesite. The defendant in this clip here is admitting that he was with Terrell Franklin and that Terrell had got into it with Omar Dana, and he thought it was all about what happened at the gravesite. We know that Terrell Franklin was not on good terms with Omar Dana on December 26th, and the defendant was close, good friends with Terrell Franklin. The defendant goes on to confirm that he was with Terrell Franklin at the cemetery on December 19th.
Anything more about the crime that we're investigating? Maybe I just haven't asked the right question, but do you know anything more about this crime? Because we're not going to stop investigating it. It's a murder. Do you know anything more about this crime than what you shared with us today?
No, sir.
You're just completely shocked that you're even here because
I really thought this was with the graves, you know, because the graveyard shit, because when Earl got, he was talking about he had to kill somebody, so really I'm already thinking I was doing bullshit because I was with him when he hit that Wild West, you know, so I didn't know what really happened, so I didn't know.
So here the defendant is saying he was with Terrell Franklin at the gravesite, but the defendant left. And then what does Terrell Franklin do? Well, we know that he goes on later that night to get arrested at 47 Canton. So from that, Terrell Franklin is upset with Omar Dana, and it's reasonable to conclude that the defendant was also upset with him. He was close with Terrell Franklin. They all were in that circle. This group was not on good terms with Omar or Maya on the date that she was killed. And what we know from this case is that regardless of motive, so that that's a possibility as to why this happened and what the motive was. But regardless of the motive, the evidence leads to the shooter in this case. And all the evidence leads to the defendant. We know it wasn't Terrell Franklin, right? Terrell Franklin was in jail. We know it wasn't Marquise Welch because he was the driver of the getaway car. All the evidence leads to this defendant as the shooter. So you heard from a number of witnesses in this case, and heard and saw all of the evidence that was presented. And it started with the officers responding to the scene on December 26th for the call of shots fired in that area at 47 Canton. And when they arrive, and that's exactly what they find. They find the neighbors there, right, the Ericas, if you will, both Erica Atkinsons, who lived at 43 next door, and then they find Maya Kelly where she died, right on the other side of her front door. And you saw that video from Officer Middleton, who was one of the initial officers on scene, show you kind of what the chaotic scene was when he arrived. And that you saw Omar Dana come out of that house, out of 47 Canton, because he had been in there and had been with Maya when she was shot and killed by the defendant. Omar Dana told us that Maya went to answer the door because there was a knock, a somewhat quiet knock, and Maya went to answer the door. He told you that the door was never opened, but she went over towards it. She said something to the effect of, "Who's there? Who is it?" And the voice on the other side responded in a way that was disguising his voice, trying to avoid detection. And Maya looked out the peephole and she did not see anyone outside. So that person, who we now know was the defendant, knocked again. And so Maya Kelly was talking to Omar about, "Oh, someone must be playing. I don't see anyone." She looks out the peephole and doesn't see anyone there. They must be playing. And the evidence in this case shows that she had turned because she shot on the left side of her head. She was talking to Omar when the shots rang out, and Dr. Stark told us that she did not have a chance to survive that type of injury. Dr. Stark also told us that she had the material or the defects on her face consistent with being shot through the door, because all the evidence shows that door was never opened and she was shot through it. Omar Dana, through the course of the investigation, talked to detectives. He talked about problems that he had with people, including the December 19th incident. And he told detectives, specifically Detective Wolf, that the bullet wasn't meant for Maya. It was meant for him. But regardless, in one legal concept that you will be instructed on by the judge is, of course, I think as I mentioned during jury selection, at the end of this trial, you are the experts on the facts, right? The decision is yours. You're the experts on the facts. Judge Quist is the expert on the law, and he will give you the law you are to follow. And I believe he will give you an instruction on transferred intent. So even if the bullet was meant for Omar, the crime is the same when it struck and killed Maya Kelly. The jury instruction reads, if the defendant intended to kill one person, but by mistake or accident killed another person, the crime is the same as if the first person had actually been killed. The crime is the same. Omar Dana told you during his in-court testimony that Maya never opened the door. The door was never opened at any point. His conversation with Officer Van Vliet was captured on body-worn camera. And Omar Dana gave his statement to Officer Van Vliet about what happened. And in that statement, of course, you'll have this to listen to as well. Because Mr. Kirchhoff was asking some questions about, well, didn't you say the door was open? Didn't Maya say, she went over to the door and you said the door was open? Nowhere on this video does Omar Dana say that. He says Maya went to the door. He never says she opened the door. And of course, you can listen to that as well. But in the video, it says she went to the door. He never says that she opened the door. So even though Officer Van Vliet testified to that, the evidence shows that he was mistaken, because this video speaks for itself.
so I could live on the police and I got the neighbors, but the neighbors, I was so scared the neighbors made me for help. I yelled out the window, who is it? I tried, I did everything I could for her. I tried, bro. I'm scared, bro.
So, you didn't see who it was?
No, nobody saw it through the door. You see the shots, so I promise you, sir, please, you somebody give her some help, please. I quit. Yes.
Remember last week
Yes.
with Mr. Terrell?
Yes, that's my cousin. That's my cousin.
Terrell had your news.
Huh?
Terrell had your news.
I don't know. He's in jail to my knowledge. I don't know. I don't know. That's why. Sir, can you please, can we do this, sir? Can we do this? Is there any way possible where I can get like, her parents, my parents are downtown, and we just talk? Please, yes, can we please, sir? I need the car. I need some comfort. Yes, those are our kids.
Are they okay with staying with the neighbors? Just to hang this for summer safety.
Tonight? No, I don't know. I don't know. I didn't do it. I don't know who's involved. I'm scared, sir.
Okay.
Please.
Where do her parents live?
They stay in Cedar Springs.
What's her mom?
Angela, yes, her father's name is Robert Kelly. Sir, please, I'm so scared right now, sir. Please, can you please give me like some type of security? Is there any way I can, sir, please give me somewhere where I can talk to her parents, my mom, everybody, please, sir. I'm scared right now. Arnold. Her father's name is Robert Kelly. Oh my God, I'm losing my mind, bro. I just witnessed my girl get her bro. Please help me, something, sir. Please keep good, bro. I'm scared, bro. I'm scared.
In this video, Omar Dana never said, Maya, open the door. And Omar Dana never said there was an argument. The evidence shows that Officer Van Vliet was mistaken about that. The video shows that Omar Dana said Maya went to the door and there were some words exchanged. Not that the door was open and that there was an argument. Listen to it yourselves. So after the officers arrive on scene and speak with Omar Dana and try to save Maya Kelly, the officers continue with their investigation and speak with neighbors on scene. Forensic personnel arrive to process the scene. We hear from the Erica Atkinson, both of them, both Ericas, that they hear approximately 3 to 4 shots. They did not hear any argument or any real discussion, and they did not hear or see anything unusual before the shots were fired. They did not see the shooter. Forensics found a bullet perforation of the front door. Forensics also found 3 9mm Luger casings in the snow. No prints were obtained from those. And officers continued to canvass the area for suspects, evidence, and video. When both of the Atkinsons were testifying, they talked about seeing a dark car driving down the street towards Division after the shots were fired. They didn't know anything more about that car. They thought they saw one person as the driver looking towards the house. They didn't know if they were involved or not. It was just something they noted after the shots were fired. So we can take a look on the video that we have from 23 Canton around that exact time, which shows 2 dark colored cars, which was one of them may have been what the Atkinsons were referring to. But let's look at the timing here. Yes, please, thank you. So we're going to push play now. In about 5 seconds, you're going to see the defendant enter onto the screen running away from the shots. The shots had already happened. So the defendant already ran across the screen. the one black car that already went across the screen, they came into view after the shots were fired. And this other black car that we see, or we'll see in a moment, on the right-hand side of the screen, I ask you to look at that. Keeping in mind that the shots had already happened, the defendant has already fled the scene. And now we start to see that there's a dark colored vehicle going towards Division, right? After a lot of time had already passed from the shots and from the defendant when he was fleeing the area. I mean, wouldn't you think if that car was involved in any way, why would it be sticking around? If that car was involved in any way, it would have fled, just like the defendant did. I mean, we can see from this video that it was a normal residential area, right? There's a lot of regular activity happening. We saw earlier in the video on the upper left-hand side of the screen, which is at 20 Canton. There was a truck there with headlights on. You can see in the back of the video that there's cars kind of traveling around the block. This was regular activity was taking place, right? Cars going up and down the street. So if that vehicle was involved, would you expect it to stay there for so long after the shots were fired? No, it would get the heck out of there. That vehicle was not involved. That's not what the evidence shows. But of course, both Ericas mentioned it because it's something they saw. They saw a black vehicle, which we see on this video, but the evidence shows it was not involved. Just have a moment. Stacy, what was that trick you said? Oh, it's back on. So never mind. So you heard from the officers and witnesses on scene that day, on December 26th, right? From Officer Middleton and Van Vliet, who were investigating. Officers canvassed the area, tried to collect video surveillance, but they didn't find any other pieces of evidence or suspects then. But we see what happens on December 27th. On December 27th, there's a break in the case, if you will. That Officer James Smith arrests Marquise Welch in this vehicle the day after the murder. This arrest of Marquise Welch in that vehicle allows investigators to determine the connection between Marquise Welch and the defendant, right? Because at this arrest of Marquise Welch from this vehicle, they're able to seize his phone, right? And by looking into Marquise Welch's phone, they can see the communications that he's having with this defendant on the day of the murder. So at that point, they look into those communications further and realize there's a connection there. So you heard from Detective Derek Hall, who was one of at least 3 detectives assigned to this case. And Detective Derek Hall was tasked with a lot of the video surveillance, either collection or analysis, right? He also analyzed some of the text messages. He was able to get some records related to the transaction at the Big Top store, and he was able to obtain a lot of video surveillance. And thank goodness he did, right? Because a lot of those businesses had a lot of good surveillance video from December 26th, so that the defendant and Marquise Welch couldn't avoid detection, because the officers did a thorough investigation of obtaining that video surveillance, and there was some good video, and it was able to tell them a lot about this case and a lot about what happened. And so what do we know from all the records, the messages, and the video surveillance as it relates to this case? Well, we know that Marquise Welch was communicating with the defendant in the hours before the murder. We know that the defendant and Marquise, they had each other's numbers stored in their phone. Marquise Welch told the defendant, who was identified as K-Man in these records, that he was about to be outside. And through the analysis of these records, the detectives were able to determine that that was at the Big Top store. Marquise Welch tells the defendant about to be outside. He tells him, I'm here around 4:36 p.m. So we know they're with each other earlier in the day, around 4:30. The defendant in his text messages says, I'll be there in a minute. I'm in checkout now. Detectives were able to determine that the number associated with Keyante Newbern was 856-6753. And the defendant later confirmed that phone number, that it belonged to him, and that he absolutely had his phone on him on the day of the murder. He had that phone for approximately 4 years, and he confirmed the number.
Is it a cell phone?
Yes, sir.
What's your cell phone number, sir?
616-856-6753.
And is that phone in your name?
No, it's not.
Whose name is the phone?
My fiance,
What's her name?
Arfa Sharif.
Okay. And you guys have,
So we know it was the correct phone number. We know it was the defendant's phone number. He admitted to that. We see in some of the video surveillance from the Big Top, you can actually see him on that video surveillance with his phone in his hand texting. And all of that matches up that at that very time, he's texting Marquise Welch, who is about to pick him up outside. We know that from his phone records, and that also matches up with the financial record that we see here from the Big Top market. That the defendant used a card to conduct a transaction in the amount of $20.24 around 4:38 p.m., consistent with all the other evidence in this case. You see in this photograph from the Big Top interior surveillance that the defendant is wearing a very distinctive coat, dark on the top, white on the bottom, and he has a Michigan hat on. He also has a hood up. You saw and heard from the officers involved in the search at 36th Street in the city of Wyoming, which was the apartment of his fiancée. That Michigan hat was found there. No question that the person in the Big Top photographs and video surveillance was the defendant. We know this is Marquise Welch's car. From the video surveillance, we know that Marquise Welch picked up the defendant in that vehicle at the Big Top on the day of the murder, just hours before. They were clearly together. That's what the evidence shows. So we know that Marquise Welch and the defendant were together in this vehicle on that date. Earlier in the afternoon at the Big Top, and we also know that they were together after the shots were fired. Additional video surveillance was found at Luna Auto on Canton, and in this photograph we see the defendant running away, fleeing the scene after he had just shot Maya Kelly in the head, wearing the same very distinctive coat, black, dark on top, white on the bottom, running towards Marquise Welch's car. Marquise Welch, who we know that was his vehicle. He's admitted to you during court that that was his vehicle. It belonged to his mom. He drove it a lot. Very distinctive vehicle, right? With distinctive damage on the driver's side and also some distinctive damage on the passenger side. So the evidence clearly shows that was Marquise Welch's vehicle. The evidence shows that the defendant got into that vehicle after Marquise Welch backed into that area. When I said earlier that he was acting as a driving the getaway car, that's what the evidence shows here, right? That he had dropped the defendant off in that area after they canvassed around the block 2 times He knows exactly where he's going to park. He backs in, he turns his lights off, and waits for the defendant to come back. And that's exactly what the defendant did. He comes back running. He runs back to the car, gets in the vehicle on the passenger side, just like they had planned. Through the investigation, we learned the timing, of what happened back on December 26th. From the video surveillance, we can see that the Dodge Journey was on Canton for the first time at 9:46 p.m. That's the first time they drive around the block, right? To make sure they know the house is there. They're looking what's going on. They're canvassing the area at 9:46. They drive back again, and you saw that the route that they took around the block. Marquise Welch drives the defendant back around, and this time he drops the defendant off, as the defendant requested, in front of 47 Canton. So then as they talked about previously, because they had to have some sort of plan for this, after Marquise Welch drops the defendant off in front of 47 Canton, he goes and parks down the street and waits for him. 9:50, the sound of gunshots on the Sunoco video, which is consistent with the time that Omar Dana told you about. I believe he said 9:49 was the time that he remembers. And we hear the gunshots at 9:50. And then at 9:51, after the defendant had run back to the waiting Dodge Journey, we see the Dodge Journey on video westbound on Hall at 9:51. So they were in and out between 9:46 and 9:51. Where did they go from there? Well, we know from the evidence that from there they leave and they head back to the 36th Street area, right? That's what the cell data shows, the phone records show that. And we also hear that from Caitlin Hines. You heard from Caitlin Hines during this trial that she knew Marquise Welch. I think she said that she had planned on smoking some weed with him, that she expected Marquise Welch to come to her apartment, but she was surprised, right, and confused when the defendant is also in the car. That he's kind of slouched down, as she demonstrated, in the back seat. She wasn't expecting him. She was expecting Marquise Welch. But it shows that the defendant was still with Marquise Welch after the murder, after they had taken off from that Luna auto. That's where they went, to 36th Street. The defendant was still there. And Caitlin Hines identified the defendant in court. She said, yes, that was him. I didn't really know him before, but yes, I would recognize him, and that's him. I mean, is it really that surprising to you that in the beginning of this investigation, she might not have wanted to get involved? Or that when detectives are showing her pictures and asking, do you know this person, or do you know anything else about this person, that she says no. Caitlin Hines is another example of a witness who was reluctant, not wanting to cooperate with the police. But now she was brought into court and put under oath and asked, would you recognize that person if you saw him again? And she said, yes, it's him. So you also heard from Marquise Welch, of course, during the course of this trial. He told you many things. The majority of things, if you recall and think back to what he admitted to, he told you about things that he really couldn't get away from, that he couldn't deny, right? Things like the text messages, things in black and white that can be shown to him, right? This is your phone, this is you. Yes, it is. He couldn't get away from that. Or the cell phone location data, or the fact that his car was on video, backed in, turning his lights off at Luna. So he couldn't get around that. So of course he's admitting that to you. So I ask you to compare that, when you're deciding at the end of the day who to believe and what to believe, because of course that's your decision, as it is in every case, right? You have to decide as a witness, are they telling the truth, are they lying or mistaken? I ask you to consider all the facts, look at everything. And for any witness, and I believe the judge will instruct you, that you can choose to believe all, none, or any part of what a witness says. So when it comes to Marquise Welch and you're debating, what do I believe? Well, how do I do this? I submit to you and I ask you, believe the parts that match up with all the other evidence in this case, right? He's telling you many things, and the majority of those things are corroborated by other pieces of evidence. Because of course, any witness can say anything, right? A person can take that stand and say whatever they want. So corroborate it, look back to all the other pieces of evidence that match up to what Marquise Welch said. There were some things he couldn't get around. But he tries to lie about other things, right? He's asked during this trial and by detectives during the investigation, why were you going there? Why were you going to 47 Canton? Why are you taking the defendant to 47 Canton? Marquise Welch says, I have no idea. Do you really believe that? No. Do you really think that he had no idea why he was taking his friend to that street? That they weren't talking about it, whether it be the week before, or the hours before, or at the video shoot, or in the car? Of course they were. That's what makes sense. And I ask you to use reason and common sense, and I think everybody does in this trial. And to make reasonable inferences from the facts you have. These guys are friends. They're hanging out all day. And the defendant's not going to say anything about why he wants to be dropped off in front of 47 Canton? Well, of course he did. But Marquise Welch isn't wanting to tell you that. So he's trying to get around that. What else does he try to lie about? He also tries to say, well, the defendant didn't say much when he got back into the car. Really? After the defendant comes running back, after he's just dropped off in the middle of the street, he comes running back, and he doesn't say much about what happened to Marquise Welch. Does that make any sense? Well, no. Even when we heard from Marquise Welch, there was some kind of argument. The defendant was saying I wasn't going fast enough. Don't you think Marquise Welch is going to ask him, well, why? What's going on? Of course they're going to have a conversation. But Marquise doesn't want to tell you about that. Marquise Welch tries to say that he was threatened and coerced into saying that he heard the defendant say, I shot that bitch. You heard from Detective Bayless, who was involved in the proffer interview, that no threats were made to Marquise Welch. Of course, there might have been some pressure put on in an interview like that, right? Which is probably pretty understandable when you have witnesses. We heard about from Detective Bayless, witnesses aren't always eager and wanting to come forward to the police. And so often detectives have to deal with reluctant witnesses. So no threats were made, but maybe a little pressure to get to the truth, right? Because Detective Bayless said, we had all this other evidence and we knew it wasn't matching up, so they're trying to get Marquise Welch to tell the truth. There were no threats, but Marquise Welch is trying to get you to believe that now. So do we think that Marquise knows more than he told us? Absolutely. Do we think Marquise Welch knows more than he told you? Well, absolutely. That's what the evidence shows, and that's what common sense and reason would dictate, that he would know more because he was with the defendant before and after. But as Mr. Faber alluded to in jury selection, and in his opening, I believe, he talked about this will be a study in human nature, right? You're going to see the complicated dynamics associated with balancing self-interest, Marquise's self-interest, versus loyalty to a friend who just committed murder. And how far is Marquise Welch going to go in acknowledging his involvement in the murder? So Mr. Faber was absolutely right that you were going to see this study in human nature and that complicated balancing act, weighing the self-interest versus loyalty. And that's what you saw play out in the different statements of Marquise Welch. The investigation continues, and it reveals that Marquise and the defendant were at a video shoot on the day of the murder. So we know through the other evidence that the defendant and Marquise were at the Big Top. They were together. The investigation also shows they were at a video shoot later in the day. We know from Isaiah Smith himself, and also the rap video itself, that there was a video shoot that took place on December 26th, and it took place on College Avenue. During the investigative subpoena interview with the defendant, although we knew it from other means, right, from the video and from Isaiah Smith, the defendant also confirmed he was at the video shoot that day.
Yeah, well,
Leaving from where?
Party was a little get together. He was having a little video shoot. My friend was Isaiah. And he about locked up because he was going through something. He was having a video shoot. Got the time to get it there. And I left from here. And I went home. I was drunk. So I was drunk.
Where was this video shoot?
It was on the north side. It was at a BRB. It was like one of them where they rent out the little townhouse, but it was on the north side. Say College. It was like on College. How did that be nowhere? That was on College. Like closer going towards, like by the highway. Off College, go past like a little highway, right? It's like a little bit, like before that. Like a little bit before that, and that's...
You were filming like a rap video?
My friend is a rapper.
So the defendant, in his own words, is confirming what the other evidence already showed. Because the evidence from the video shoot, from the portion of the music video that we had, it showed that the defendant was there. It showed that he was wearing that distinctive coat, dark on the top, light on the bottom, a black ski mask on his face, and that the defendant was in possession of a gun on that day. At various points, it's hard to determine, exactly the type of gun that he had on that day because of the lighting, but the defendant was clearly in possession of a gun. We see that from the music video itself, and Isaiah Smith also told you. Yes, the defendant had a gun. Numerous people handled the gun at the video shoot, but yes, the defendant had it. Either the defendant or Marquise brought it because it wasn't there before they got there, but when they arrived, then the gun was there. And that the blue laser sight had been on it the whole time, and the gun arrived when Marquise and the defendant arrived. There are numerous different views of the defendant possessing that gun. All the evidence shows there was only one gun. It was a black gun. And all the evidence shows that the defendant had it at numerous points in that video. The gun had a blue laser sight attached to it. In this photograph, Isaiah Smith was holding it. But that is the same gun that arrived at the video shoot at the same time as the defendant. The one and only gun that was there that day, with a blue laser light. So as it relates to the gun and the blue laser light, we heard from Detective Sergeant Russell Karsten with the Michigan State Police, an expert in firearms. Among many other things that he told you, he said that all 3 9mm casings that he examined were fired from the same gun. That the primer strikes on the back of the casings were consistent with a Glock firearm. That the bullet was fired from a Glock barrel. Detective Sergeant Russell Karsten, along with Officer Bradley Cutright, 2 law enforcement officers with many, many years of experience, said that a blue laser sight is not very common. That it could come in different colors, right? But in all their years of experience, over 25 years, I believe, that a blue laser sight is pretty rare. It's not very common. That the more common colors of lasers are red and green. You know, when he was saying that, it was interesting because the lasers even that we used here in this trial, the laser pointers, red and green. Blue laser sight, not very common. And then we also saw Detective Sergeant Karsten with his demonstration that the blue laser sight fit perfectly on the training gun that is used by the Grand Rapids Police Department, which is an exact replica of a Glock 17. And it wasn't too difficult to attach either. I think he did that in just a few seconds, if you notice, with a small screwdriver. Easily on, easily off. But that type of laser sight is specifically intended for a gun, not to attach to anything else. So the evidence in this case just shows more about the time frame or the timeline involved. After the video shoot, we know that they go directly to Canton Street, right? So from the video shoot, directly to Canton Street, because of course the defendant wants to go there. We know that the last outgoing call, which I believe we heard from Mr. Heikela, not officer, the last outgoing call from the defendant on his phone was to Marquise Welch at 9:34 on December 26th. Last outgoing call. They leave the video shoot around 9:35. They head directly there. The cell data puts their phones, off the towers near Canton around 9:47. The time of the gunshots again was 9:50. And in my previous slide, they were already heading westbound on Hall at 9:51. And interestingly, and I'm sure you took note of, that Marquise Welch, when you're considering, is he telling us everything he knows? Consider this fact. Mr. Heikela told us that from 9:44 to 10:04, there was no cell data for Marquise Welch. He turned off his phone or put it in airplane mode, because we know that there was activity before and after, right? But during the exact time of the murder, between 9:44 and 10:04, no cell data for Marquise Welch. Why? Because he knew what was going on. He knows more than he's telling you. He turned off his phone. He didn't want to be associated with it. He didn't want anyone to be able to detect that. That was an intentional act on his part of turning off his phone or putting it in airplane mode. So the investigators and detectives in this case, used all means that they had to find the truth, to figure out what happened. Another tool that you heard about here was the investigative subpoena. It's a tool that's used in these types of situations, right, where you may have some reluctant witnesses who aren't always eager to cooperate with the police. An investigative subpoena interview where that witness is given all of their rights and read their rights. They can have attorneys present. And that's what happened in this case. And why was the investigative subpoena important here? Well, you heard from the defendant. You heard his words from his mouth. And I asked you to consider, we've already talked about what did Marquise Welch try to lie about. Now consider, what did the defendant lie about during his IS interview? He lied about a lot. He lied about very important points in time, points that would connect him with this murder. And I'd like to go through some of those. So what did the defendant lie about during his IS? Mr. Faber asked him numerous times whether he was at or near 47 Canton on December 26th. And what was the defendant's answer? No, I was nowhere near there. And let's hear it in his words.
At the time that this murder occurred, were you present at or near 47 Canton Street Southwest? And that was December 26th of last year, about 9:50 p.m.
You keep saying last year, my bad. Because I keep here, we get a new year. I'm like, you saying the whole year. But no, sir. No.
Anywhere, do you know where you were that day?
Of course, he's trying to distance himself from the murder, right? He's asked those specific questions and denies being at or near 47 Canton. He's asked numerous times, and he lied numerous times. Let's hear his words again.
Do you know the address, 47 Canton? Let me show you a picture of the house. Exhibit 15, and then it's the same answer, it's also color. You recognize that house?
I ain't never been on Canton, the street, I don't know, where is that, where is the line?
Division,
Oh, I ain't never seen, I never been over there before, though, boss man.
So, that house, 47 Canton, on Exhibit 15, you've never been to that house?
I've never been to that house.
When you say you've never been, you mean never been inside? Or never been at the house outside of it?
I ain't never been by that house. I've never been. I don't.
Do you know anybody that is associated with that house? Anybody that stays there or stayed there?
I don't really think that's not my side of town. Like, that's not, I can't even be over there. That is not my playground to be at, so I don't really, I'm from the south side, Venus area. Over there, I can't even go, can't be around there.
The defendant was even shown a picture of the house, and he again lies and says, I've never been to that house, anywhere near that area. I don't know anyone associated with that house. You know, even though we heard evidence and testimony all about how one of his close friends, Terrell Franklin, has a beef or a disagreement with Omar Dana, who lives at that house. I mean, that's no coincidence. Again, defendant trying to distance himself with the murder. Defendant tries during his IS interview to distance himself with anything that can really connect him with the murder. And who's the closest person from December 26th that can connect him with the murder? Marquise Welch. So what else does the defendant lie about during his IS? He lies about being with Marquise Welch at the video shoot that day, and lies about being in the car with Marquise Welch that day.
Did you see him on December 26th? You've already testified about being at this video shoot at B&B on College. Was Keith there?
I don't know, I wouldn't know. I'm not sure, no. Because he would have gave me a ride then.
What's that?
I said he would have gave me a ride then. No, he wasn't. No, he wasn't there.
He might have given you a ride there?
No, I said he would have gave me, I would have got a ride from there, like, yeah.
But it's your testimony that you didn't?
No, he wasn't. I did not see him there. Like, he was not there. Like,
Did you see him at all that day?
yes.
Tell me where you saw him.
I saw him at my house. That little, only last time I saw him was at my crib. He pulled up, said hello, because he lives right by me on 44th. His baby mom stayed on 44th. I live on 30. My fiance, I live over there, except for 36, right here by my apartment. So he come like it's quick action. But like that's why I'm sleeping that day, because the road was just he on his own 1, 2, 3. Like,
Did you talk to him that day?
Talked to him that day. He said I would talk to him and that when he came. That's the time I really got talked to him. I talked to him over the phone or nothing.
And other than, and was this at your place or in the parking lot?
That he pulls up to my place. He comes in.
And was he in that silver Dodge you testified to already?
Yeah, that's his mom's car.
Okay, that's the car that he drives all the time?
Yeah.
Did you get in that car that day?
No.
So the defendant denies during the IS interview ever getting into the car with Marquise Welch on that day. He denies him being at the video shoot on that day. The defendant tries to say, the only time I saw Marquise Welch was for a really quick, short time at my apartment. The defendant doesn't say anything else about being together at Big Top, being together at the video shoot, being together on Canton, being together after, being in the car with him. He lies about all of that. What else did he lie about? The defendant lied about possessing or even seeing a gun on December 26th. Again, on all these points that could connect him to this murder. The gun, Marquise Welch, those are the main things that the defendant is lying about.
Did you fire a gun that day?
No, sir.
Did you possess a gun that day?
No, I don't
Did you see a gun that day?
No.
We were just talking about a rap video, so it's completely different, but on college, at the B&B, during the video, I've seen enough videos to see that even if they're real or not, guns are very common props in videos.
Right.
You know, is that fair to say?
Yeah, it is. You know, that's the main thing that people put in their video.
If we get that video or videos that you were part of filming, are we going to see you with a gun in your hand?
No.
Okay. You're good. You're confident about that? I'm not trying to trap you. I just want to make sure that.
No. It's good.
Okay, so no, you did not possess a gun or anything that looked like a gun that day.
Hell no. No.
And so the defendant was asked if he possessed a gun or anything that looked like a gun that day. And what does he do? He doubles down. Hell no, he says. Well, we know that's a lie, based on all the other evidence in this case. We know that he possessed the gun, definitely looked like a gun. We know it was consistent and it looks like a Glock 17. We know he possessed the gun on December 26th, just in the hours before the murder. We know he possessed the gun on April 1st of 2022, in the months before the murder. You heard that once his phone was seized and collected from the search warrant in Lansing, it was forensically downloaded and examined by detectives, and that a photograph from April 1st of 2022 was located on the defendant's phone, showing a Glock firearm in his left pocket, and that was on his phone. I believe the witness identified that it was the defendant's hand, and that Coach wallet is consistent with the one that was seized from the 36th Street apartment. So this photograph shows the defendant holding a Glock firearm on April 1st of 2022. You heard from the detectives who conducted those searches, at the addresses associated with the defendant. Because at the time that he was taken into custody, that was from Lansing, right? But he was associated with other addresses, including the address of his girlfriend or fiance, Arafat. Officer Romero found an ID wallet and a phone in Lansing during that search. And that was the phone that was downloaded and showed the photo of the defendant with a gun on April 1st. Officer Cutright found the laser sight and the Coach ID wallet at the 36th Street apartment. And it was a laser sight that is specifically intended to mount on a gun. So it begs the question, where is the gun that attaches to that laser sight? He had the laser sight. It's reasonable to conclude that he got rid of the gun, but he still held on to that laser sight. And we know it fits on a 9mm Glock. We saw that demonstration here in court. And of course, the location where this laser sight is found is very telling, right? It was found in a place where the defendant hid it. That he hid it in a gift bag in a closet in what appears to be a child's room. He was trying to hide it. It wasn't found near some of the other stuff that was taken, but that's showing that his consciousness of guilt. He's trying to get rid of this, or at least hide it. We know he got rid of the gun and the coat, two things that are very able to link him to this crime, right? But he kept the laser sight, probably to attach it to another gun at some point. But he gets rid of the gun, he keeps the laser sight, and he hides it in a place that he hopes officers or anyone will find it. But luckily they do. And when it's activated by officers, it's a blue laser sight. Again, that's very not common and rare. They find the Michigan hat and the Coach wallet during the search of the 36th Street apartment. The Michigan hat consistent, of course, with what the defendant was wearing on the day of the murder at the Big Top store. So all of these things taken together are showing the defendant's consciousness of guilt. He knows what he did, and his actions are showing that. That he is arguing with Marquise Welch that he wasn't going fast enough, as Marquise Welch is driving him away from the scene. He needs to go faster. He needs to go faster. The statement after the murder that he hears, the statement after the murder that he says, "I shot that bitch." He knows exactly what happened when he was at the door at 47 Canton, and he comes back to the car, running back to the car, and makes this spontaneous statement, acknowledging what he did. He stayed with Arafat after the murder, not his registered address that we see on his license or on his identification, or that he gives during his IS interview. He was found in Lansing. That'll be up to you to determine whether he fled to Lansing after this, or if he was just going to visit his aunt, as she would have you believe. But regardless, he was not found in the Grand Rapids area during the week after the murder. He went to Lansing. He got rid of the gun, but he kept the laser sight. He hides it in a bag in that room near children's clothing in a gift bag. Why is he keeping that? It's specifically intended to mount on a gun. Like I said, probably keeping it to attach to a different gun. And also, what else shows his consciousness of guilt in this case? All the lies, the numerous lies, the many lies he tells during the investigative subpoena. As we talked about during opening statement and jury selection, what the standard here is that we fully accept, or what the burden is, that the elements have to be proved beyond a reasonable doubt. We talked about it's not to a 100% certainty, but it's a doubt based on reason and common sense, not something imaginary, but it has to be a doubt that could really, attach to something based on the evidence or lack of evidence, a doubt you can articulate to fellow jurors. Not imaginary, not just possible, based on the evidence in this case. And there is no reasonable doubt in this case based on all the evidence that you have, all the overwhelming circumstantial evidence and direct evidence. It's not reasonable doubt that there is no eyewitness to this crime, right? Eyewitnesses are direct evidence, but as we talked about earlier in jury selection, that can be subjective. That once you hear an eyewitness, you might question that, but that's subjective. It doesn't always speak for itself, like circumstantial evidence does. And in this case, the circumstantial evidence is overwhelming when you put everything together and everything matches up. Another jury instruction that you will get from Judge Quist, I believe, is that you should consider all the evidence that you have, right? You can convict solely on direct evidence, solely on circumstantial evidence, or a combination of everything that you have. So circumstantial evidence does not mean that it's any less than direct evidence. It's the quality of the evidence, not the type. And in this case, the circumstantial evidence and all the evidence together is overwhelming. The evidence shows that the defendant committed this murder. I'm giving him all the benefit of the doubt based on the facts of this case. At the very least, starting as a baseline, he is guilty of second-degree murder. You will be able to determine the degree of murder that he is convicted of. You will be able to decide between first-degree murder and second-degree murder. And again, I submit to you at the very starting at a baseline is he is guilty of second-degree murder. These are the elements that have to be proven beyond a reasonable doubt in order for him to be convicted of that charge. That first, he caused the death of Maya Kelly, and second, that he had one of 3 states of mind. And I ask you to keep in mind that here, for second-degree murder, a person does not have to intend to kill or have the intent to kill to be guilty of this charge. The person has to have one of 3 states of mind: intent to kill, intended to do great bodily harm, or knowingly created a very high risk of death or great bodily harm. Like in a case like this, where shooting through the door when the defendant knew someone was on the other side of it, because the evidence shows he was having some conversation with Maya Kelly. He knew she was there. At the very least, he knowingly created a very high risk of death or great bodily harm. At the very least. That's why I say start with that as your baseline, that he is guilty of second-degree murder. But I submit to you, he is guilty of first-degree murder. And that's what I ask you to hold him accountable for, is first-degree murder. And as we talked about before, even if you believe that the bullet or the bullets were intended for Omar and struck Maya instead, the crime is the exact same under the law of transferred intent. The evidence shows that the defendant is guilty of first-degree murder because these 5 elements have been proved beyond a reasonable doubt. That the defendant caused the death of Maya Kelly, that he intended to kill, the intent to kill was premeditated, the killing was deliberate, and that the killing was not justified, excused, or reduced to a lesser crime. So one of these elements that you have to decide, of course, is whether the intent to kill was premeditated. So premeditation, as you will get these jury instructions as well, it means that it's up to you to decide if enough time passed under the circumstances of this case. The law does not say how much time is needed. But from shows and television and movies, when the concept of premeditation is thrown around, you might think that it requires days, weeks, years of planning, writing it down, things like that. That's absolutely not required. Premeditation can form in the matter of seconds. The law does not say how much time is needed. It is up to you to decide if enough time passed under the circumstances of this case. So in order to determine that, if enough time passed, I ask you to look at all of the defendant's actions, break them down, and look at how many decisions that he had to make. The idea is that there has to be enough time to think twice, right? To have a second thought about it, not to be just a sudden impulse. And all the evidence here shows that the defendant thought about this for a while. Whether it be the week before, or hours before at the video shoot, or on the way there, or as he was walking up. There are many different facts that show premeditation. The defendant tells Marquise to take him to Canton Street. Take me there. He's already thinking about what he's going to do. They drive around the block to canvass the area. All acts of premeditation. He gets out the second time that they go around the block. He has to get out of the car. He goes armed with a Glock. That's a deliberate action, an intentional action. He has to walk up to the house after getting dropped off, getting out of the car, opening the door, getting out, walking up to the house. He has all of this time to think about what he's going to do. He has time to think twice. He knocks on the door. Not just once, but he knocks on it twice. He says something to Maya. He tries to get her to open the door. We heard from Omar Dana that the defendant, tried to disguise his voice. It sounded like a weird voice. The defendant also, tries to avoid detection because Maya Kelly didn't see anyone out of the peephole. So it's reasonable to conclude that the defendant was trying to hide himself. He's taking that act for action as well. He knocks on the door again. These are all separate acts of premeditation that show what the plan was. And all the actions that I just described don't even take into account any planning that went into it beforehand, right? Those actions are just when he goes there from the video shoot. It doesn't take into account any planning that might have happened at the video shoot itself, or in the hours before, or in the week before, when Terrell Franklin and the defendant, are mad that Terrell Franklin got arrested from 47 Canton because Omar and Maya may have snitched on him. We know there was some sort of plan. The defendant knew exactly where to run. I mean, how did he know exactly where to run after he shot Maya Kelly? I mean, we saw in the video surveillance that there was many places that Marquise Welch could have parked, right? In driveways, along the street, in the other direction. But the defendant knew exactly where to run. Why? Because they talked about it. Because there was a plan about it. That Marquise Welch would back into that space and wait. All separate actions of premeditation. The evidence shows the defendant is guilty of first-degree premeditated murder. It also shows that he is guilty of carrying a concealed weapon. To prove this charge, the prosecutor has to prove these two elements: that the defendant knowingly carried a pistol, and that the pistol was concealed on or about his person, or the pistol was concealed in a vehicle, or the pistol was in a vehicle, and that the defendant was in it, he knew it was there, and he took part in carrying it or keeping it there. Importantly, you should note that there is no requirement that if it's in the vehicle, that it be hidden or concealed. It just has to be in the vehicle that the defendant was in, he knew it was there, and he took part in carrying or keeping it in the vehicle. The evidence shows he is guilty of that count as well. He is guilty of possession of a firearm, because these elements have been proven beyond a reasonable doubt, that he knowingly possessed or used a firearm in this state, and that he was ineligible to possess a firearm. As it relates to count 2, element 2, there is a stipulation about that. So the defendant stipulates or agrees that he was ineligible to possess a firearm at the time of these acts. He is guilty of that count as well. The evidence shows he is guilty of felony firearm. In order to convict him of that count, you would have to find that the people have proven beyond a reasonable doubt that he committed the crime of murder. That's what the evidence shows in this case, that he is guilty of first-degree murder. And then when he committed that crime, he knowingly carried or possessed a firearm. So after you've heard all this evidence and sat through the course of this trial, the evidence shows that these 3 men were linked. They were connected. They were friends. They may have had motive here. And regardless of what was going on with these 3 men, it did not need to end in the death of Maya Kelly. The defendant that day had really no regard for human life. As he was shooting through that door that he knew someone was on the other side of. He knew there was a female voice speaking to him. And thank goodness those kids weren't struck as well, because they very well could have been. So no, they are not victims of this murder. But they are still victims, right? They have to continue their lives without their mother and have this image in their minds forever of their mother being shot in front of their very eyes. I'm asking you to hold the defendant accountable for that. He had the means, he had the opportunity. You hear his words that he lied so many times to distance himself from what he just did. All the direct and circumstantial evidence in the big picture shows that he is guilty, and that I ask that you return the only just verdict in this case, which is guilty of first-degree murder, possession of a firearm, carrying a concealed weapon, and felony firearm. Thank you.
Thank you, Ms. Pravat. Mr. Kirchhoff, ready to proceed? Okay, please do so.
I get to address you one time. Ms. Prevet gets a chance to come up and talk to you again. And I'm going to ask, because I only get one shot at you, to listen to me and to actually pay attention as best as you can. And I'm not going to take anywhere near what she took, because I don't have to build a house of cards. All right. Ms. Prevet's whole argument is, if it fits my theory, it's true. If it doesn't fit my theory, somebody's lying. That's not how beyond a reasonable doubt works. I'm going to ask you to listen to everything and take everything into consideration. And just because it doesn't fit her theory, don't throw it out. You know, look at everything. And let's start with this motive part. Now, the judge is going to instruct you. They don't have to prove motive. What did she spend half of the trial trying to do? Motive, where there's no motive for my client to do anything. This bit about he's friends with Terrell. Terrell gets thrown in jail a week ahead of time. It's absolutely without a doubt my client knows Terrell. My client was even there earlier but left. He had no cat in that fight, period. And he told you that. All right, while I was on the investigative subpoena anyway. But he didn't have anything to do with it. And what did Omar say on the stand? Terrell called me from jail a bunch of times after he got arrested. Now, as you might expect, our jail is set up. Yes, occasionally they are given a chance to make outgoing calls. Can I call somebody in their cell? No, it is a jail. Mr. Terrell Franklin had to place the call, and he's placing the call to his former buddy with whom he got into an argument about pissing on someone's grave that has nothing to do with my client. And what does he tell you? Yeah, he says, Omar told you, I told Terrell when he called me, I didn't snitch on you and Maya didn't snitch on you. And I asked him, well, that kind of settles that, didn't it? And he said, well, not really, we still weren't happy, but. So there's an explanation, and Terrell calls him again after that too. Did Terrell ever call my client and say, hey, go shoot somebody because I got mad at him once? Absolutely not. No communication with my client and Terrell while Terrell's in the jail after he gets arrested for whatever the heck happened in this cemetery that my client wasn't even there. And Ms. Prevet gets into an argument with her own witness, with Omar, about it, trying to get him to say, well, yeah, this must have been why it happened. And he couldn't say it and didn't. And gets into an argument with her own client, or own witness about it. There's no motive for my client to do anything, and he didn't do anything. Now, she is relying a lot upon what's in the investigative subpoena of my client. What does my client say right at the very beginning? Well, let's back up a little bit. He gets arrested around 8 o'clock in Lansing, is brought back here directly, and by 11:20 is what the investigative subpoena says, he's being questioned under oath about this incident. And what's the first thing he says? Hey, I'm still drunk from last night. I'm high. I'm on coke yet. I haven't had any sleep. And you saw his demeanor on there. He'd start laughing, or not laughing, maybe not laughing, but chuckling at inappropriate times. His answers were mostly, cogent, but his whole demeanor supported the exact fact that he was in an altered state of mind at the time of the investigative subpoena. Were all of his answers perfect and, quite frankly, truthful? I doubt it. But again, he's in an altered state of mind. He's brought into the court, sworn in, and asked questions. And he might have had an attorney there, but did you see the attorney say anything to him at all during the whole time? No. And let's look at a couple of the things that I guess matter here. Marquise Welch, I quite frankly don't know how to take his testimony. I don't know how to take what he said. Marquise Welch, according to the prosecutor, knew everything was going to happen. He drove the getaway car. He knew this was going to happen. That's why he turned off his phone. They had this discussion in the car ahead of time where there's absolutely no testimony, no evidence of any of that sort of thing happening. Marquise Welch, I don't know how much of what he said was the truth and how much it wasn't, but according to Ms. Prevette, you believe if it fits my theory. If he doesn't fit my theory, he's lying. That is not how one determines whether someone is lying or not. And let's look at what Mr. Welch had on the plate to determine, what you can believe and what you can't believe. He had gotten arrested for having a bunch of fentanyl on him. He was charged with that. He had a couple of cases he was on bond for that was a violation. And according to them, he knew this was all going to happen. He was the getaway driver. He's the one that drove him there. They talked about it ahead of time. He knew she was, that Mr. Newbern, who was supposed to be in his car, was going to get out and shoot somebody. Was he charged? No. All he had to do was tell them what they wanted to hear. That's exactly what he said up there. He said, he told them what they wanted to hear. They grilled him for an hour at that one point, and that wasn't even the whole he was only, the transcript that we have is only part of it. It doesn't show, it's not the whole thing. Now, was he threatened about having to go to prison? I'm sure he was, because quite frankly, he should have, based upon being arrested with 8 grams of fentanyl in his pocket, being on conditional bond. All that dictates that's probably going to prison. Was he? And they're adamant that he lied throughout his investigative subpoena. Was he ever charged with perjury? No. He found a get out of jail card. And that's telling what they want to hear. Did he ever get charged with the accessory after the fact for this murder, or even with the murder itself, which they could have? No. He found a get out of jail card. And he said, I played it. I told them what they wanted to hear. What specifically did he say he lied about, at least in front of a jury? He said, well, this person in the car, Mr. Newbern, supposedly, never said anything about I shot that bitch. I made that up. I also made up the part about go, 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 you got to go faster. It worked. He didn't get charged, and he only got a year in the county when he should have been going to prison. So what he said worked. It was in his best interest to tell them exactly what they wanted to hear, and that's exactly what he did. Now, I'm sure she's going to get up and say, well, that's a lie. But let's look at one corroborating thing. The only thing we can find here is Ms. Hines. Ms. Hines gets in the car after all this is supposedly done, and Mr. Newbern's in the back seat of the car, and as she put it, he's intoxicated. I get in, he says, what's going on, or how you doing, or whatever. And outside of that says almost nothing. Now, what did Ms. Hines first tell the police? I can't recognize him. The guy, I've never met him. Guy was wearing a mask. All I could see was his eyes. I can't tell you who it is. Now, what happens when we get to court? Well, she wants to be very helpful for the police. Oh, that's definitely him. I recognize him by the eyes. Even though she already said a couple times, I can't say for sure. She is doing everything she can to help the police. What does she say? He doesn't say anything once I get in other than saying hi or something like that. We pass around the joint. He's intoxicated, laying down in the back. He doesn't say anything. Now, do you think if he would have said, hey, I shot that bitch, you think that would have come out on Ms. Hines' testimony? Certainly would have. She was bending over backwards to help the police here. It didn't come out because it was never said, and at least in that regard, Mr. Welch is telling the truth. And that is corroborated. Now, Ms. Prevet has brought up a number of other things, including things like, well, he had to have gotten rid of the coat and the gun. Obviously, a gun can be incriminating, particularly if it's used in a murder or any other kind of a shooting. But what about this coat? How would Mr. Newbern know that that is incriminating? He wouldn't have. He didn't get rid of it. They just, I don't know where it is. They didn't find it. Maybe it's still at his mother's. But if you're going to get rid of stuff that's incriminating, you get rid of stuff that's incriminating. You don't keep a laser sight that would have been used in a murder if, in fact, it was used. And again, the police, well, golly gee whiz, I've only seen red or green laser sights. I've never seen blue, but they're readily available. Of course, none of them ever look to see what color it comes in or how often it's used. Now, Russell Karsten did admit there's millions of Glocks up there. And he did not put a number on it, but he said there are innumerable laser sights in numerous colors. At least that part, perfectly honest with. But Ms. Prevet goes even farther and says, hey, the laser pointers we have in court are red and green. That means Mr. Newbern did this. Her whole case is supposition upon supposition. It is a house of cards where you take one out and they all collapse. And that's not beyond a reasonable doubt. In order to get a conviction here, you have to believe this, then you have to believe that, then you have to believe the next thing, then you have to believe the next thing. And ignore anything that is contrary to that. I mean, Ms. Prevet's up here saying her Grand Rapids police officer who testified is a liar. There is no doubt in my mind that Omar Dana, rightly or wrongly, at some point prior to this tape that you can play if you want, you notice it starts with him getting in the car. Doesn't start with him the first time that he is encountered by Officer Van Vliet. Officer Van Vliet was very adamant. Yeah, he told me that. He told me the door opened, there was an argument. Now, did that happen? I don't know. But why would Officer Van Vliet make that up? The one thing that does matter here is he said, yeah, it was a really weird voice and it was a white voice. Mr. Newbern's not white. So Ms. Prevet knows that's the problem, so what does she say? The cop is mistaken. Lying, in other words. He testified under oath. Yes, Mr. Omar Danar said that to me. Who are we going to believe? I know who I believe. Certainly isn't Omar Dana over Officer Van Vliet in that situation. Now, there are certain things here that don't make sense whatsoever. That is number one. The white voice that Omar Dana heard at the door and now realizes it doesn't comport with the prosecution theory. Therefore, it didn't happen, despite what Officer Van Vliet is saying. There's other things. Jennifer Stradilak, who is a IBO tech with Grand Rapids, said, I collected GSR on Omar's hands. Collected, not tested. And she said GSR is gunshot residue. She collected gunshot residue on his hand. Did he do the killing? I don't know. But that certainly is something that the prosecution chooses to ignore. The Atkinsons, oh, they see this black car going down the street, and it's, they saw it a few seconds after the shooting. It was going real slow, and I found that to be odd. Both of them said that. But now, according to Ms. Pravette, that doesn't fit with her theory. So, oh man, there's 20 or 30 seconds afterwards, and now you see it coming in front of 23 Canton, which is all the way down the street. And therefore, if they would have been involved, they would have been fleeing. I don't think that quite fits either. If someone from that car shot, number one, they'd have to get back in the car and go back. And number two, if they knew that they did the shooting, they may speed away. But they don't have to because they know no one else is going to be shooting, as opposed to somebody running who might have heard shots in the area. And again, if it doesn't fit, you have to ignore it according to Ms. Pravette. But that is, again, not beyond a reasonable doubt. At 9:34:17, Mr. Newbern's phone places a call to Mr. Welch's phone. We have the phone records. No doubt about it. Why do you call somebody? Because they're not next to you. They're not standing together. And that would have been at the video shoot. And as Mr. Newbern said in his his investigative subpoena, he got a lift home from that, didn't ride with Mr. Welch. That would make sense if a few minutes before that, Mr. Newbern is calling Mr. Welch. Wouldn't be calling him if they were sitting next to each other at a video shoot. And one last thing in connection with that. The last thing I asked Mr. Welch was, didn't you go pick up Mr. Newbern before you went to Caitlin's? And he said yes. Again, I'm sure Ms. Pravette's going to get up here and say, well, he had to be lying about that because it doesn't fit our theory. But the fact remains, Mr. Newbern was not with Mr. Welch until Mr. Newbern, well, after the video shoot, until Mr. Newbern got picked up by Mr. Welch on the way to Caitlin's. And what did they say? They lived right in the same apartment complex right around the corner from there. So I guess we don't really have a problem with Mr. Newbern being in the back seat of Mr. Welch's car at Ms. Hines' house because he just got picked up by Mr. Welch, who admitted he just picked him up. I'm guessing, and again, here I'm guessing, and I'm telling you I'm guessing, that they went together to this shoot. Everybody kind of, I guess, agreed that Welch left the shoot to go get food. And Mr. Newbern told you in his IS he wasn't there to give him a ride, so he took a lift. But about not too much longer later after that, Mr. Newbern comes, or Mr. Welch comes and picks up Mr. Newbern, and they go over to smoke right around the corner with Ms. Hines. And again, no questions asked by Ms. Pravette after Mr. Welch said that. But now I'm sure there's going to be something said about it, that he's obviously lying in that part because it doesn't fit with our theory. Bottom line here is there are just too many holes in this. This is supposition upon supposition. It's a house of cards. You pull one out and the whole thing collapses. Mr. Newberg did not commit this murder. Was he with some of these people? Sure, earlier in the day, yeah. And later in the day, yeah. But he was not there, and they have not shown anything that proves he pulled the trigger in this matter. Thank you. I'm asking that you return a verdict not guilty on everything.
All right. Thank you, Mr. Kirchhoff. Ms. Pravette, rebuttal. I'm going to limit it to 15 minutes.
I'd just like to touch on a few things, and to start off, Mr. Kirchhoff tries to tell you that I'm only asking you to believe the portions of Mr. Welch's testimony that fits with my theory. Well, that's not accurate, because when I stood up here before, when I acknowledged you'll probably have to consider what you believe from Mr. Welch, I asked you to believe the parts that fit with all the other evidence in this case. My theory in this case is based on the evidence. So I ask you to believe the parts of Marquise Welch's testimony that fits with all the other evidence in this case, not that it just fits with my theory. My theory is based on the evidence. And of course, you heard that Marquise Welch received some type of offer from my office for his truthful testimony during this trial. So yes, in some ways he cooperated, and that was in his own self-interest. And you might not like the fact that an offer was given to him. And you know what? Quite frankly, neither do we. But his cooperation was what helped lead to discovering who the killer was in this case. And it led to the defendant. So although you might not like the offer, we don't either. Sometimes in cases like this, we need to have some cooperation to figure out the truth. So he was acting in his own self-interest, yes, but his testimony and what he told us is based on and matches up with the other evidence in this case. Mr. Kirchhoff said I got into an argument with Omar Dana. Well, I submit to you that Omar Dana was another reluctant witness. Like we've seen from the others, like Marquise Welch and Jasper Keys and Caitlin Hines. Then when I was asking Mr. Dana, tell me why this happened. Why do you think this happened? Were there some reasons for it? That's when he did not want to go into a lot of details, right? He didn't want to talk about that either. Maybe he didn't want to snitch either. We've heard, and I'm sure you can see during the course of this trial, that snitching is a big deal. It can be life or death. And Omar Dana was another witness who was showing you, that he didn't want to talk about certain things. Mr. Kirchhoff said that I stood up here and said Officer Van Vliet was mistaken because it doesn't fit with my theory. No, I said that because it doesn't fit with the evidence. I asked Officer Van Vliet, I believe at least a couple times, were any of the conversations that you had with Omar Dana captured on your body-worn camera? Yes, he said. I asked, were there any other conversations that weren't captured on your camera? No. So any conversation you had with Omar Dana would be captured on that camera? He said yes. And so that's why I played it for you at least 2 times, and of course you can go listen to it again. So I say that he was mistaken because that's not what the evidence shows. That body-worn camera shows that Omar Dana never said Maya opened the door and never said that there was an argument. He said the door, that she went towards the door, and that there were words exchanged. So why I said that was based on the evidence. The defense is trying to claim that at the investigative subpoena interview that the defendant was intoxicated. Well, you have that yourselves, and you've seen it here in court, and you can look at it again. But ask yourselves, what symptoms of intoxication is he showing? Mr. Kirchhoff points to the fact that he was laughing during that. That must mean he was intoxicated or high. But I submit to you that the defendant was laughing during the course of this trial at various points. So it's not necessarily a symptom of being high or intoxicated. It's probably just his demeanor. Because Mr. Faber even asked him during that IS interview, well, essentially you say you're intoxicated, but you seem to be understanding me. Defendant says, yes, I'm comprehending. There's nothing else in his demeanor indicating that he doesn't understand the questions or that he doesn't understand what's going on. Just because he was laughing in that IS interview does not mean he was drunk or high. Again, he was laughing at various points during his murder trial. Mr. Kirchhoff talks about some of the evidence that we didn't find, right? Like the coat and the gun. So things that it's reasonable to conclude that the defendant would have gotten rid of, because those items would have been very strong connections to this murder, and he knew that. I mean, is it really that shocking to you that a criminal would dispose of a gun that had just been committed, that had just been involved in a murder? Is that shocking? Absolutely not. I mean, isn't that what you would expect him to do? To dispose of the gun, dispose of the coat. It's exactly what he did. Please don't reward him for being smart enough to get rid of the gun and get rid of that coat. That's exactly what you would expect a person to do in these circumstances. And Mr. Kirchhoff says that we can't prove that he had a gun or that he fired a gun or that he possessed a gun. But if you look at the photos or the video that you have from the video shoot in the hours before the murder, and you look at the picture of the gun in his hand. If we could pull that up. The defendant clearly has a gun in his hand at the video shoot hours before the murder. And the gun is consistent with being a Glock 17. Could we dim the lights, please? You saw the demonstration in court and you heard the testimony about this training gun that's used by the Grand Rapids Police Department. That's an exact replica of the Glock 17. And I asked you to look and compare it to the similarities of the gun that was in the defendant's hand on December 26th of 2022 in the hours before the murder. And if you look at some of these characteristics of the trigger guard, and I'm holding it in a way that's very similar to what we see in this photograph up here. But look at the trigger guard, the space between the trigger guard and this laser sight, this little notch or divot right here that you also see in this image, the space between the trigger guard and the laser sight that you see on this training gun and that you also see in this image, and the distinctive trigger guard here that's consistent with what we see in this image. So this gun, although we can't say for certain what it is in this video, it is consistent with being a Glock 17 based on all the other evidence that we have when comparing it to this training gun that's an exact replica of a Glock 17 that's carried by Grand Rapids police officers. With this laser sight attached, this is exactly what the Glock 17 would look like, and that's exactly what we see up here in the defendant's hands hours before the murder on December 26th. Again, don't reward him for being smart enough to get rid of that gun and get rid of the coat. All the other evidence that was found and shown to you during the course of this trial shows that he is guilty. All the evidence taken together is overwhelming, and I ask that you hold him accountable of first-degree murder and all the other related charges. Thank you.